Climate change and the law are two things that councils are acutely aware go hand in hand. And I'm delighted to welcome to the stage Dr. Vernon Rive from AUT's Law School to provide us with an update on the legislative and policy frameworks and council's legal obligations around climate change.
Kia ora koutou everyone, and thank you, Mayor Carl, Grace and other people from LGNZ for the chance to speak to you today. So over the next 25 minutes or so, I'd like to attempt a whistle-stop overview of what I think are some of the significant developments in the international and domestic legal framework for climate change affecting New Zealand. We've been down in the weeds somewhat, looking at some of the policy and legal developments, so we're going to take a drone view for a few minutes, have a look at what's happening in the international law framework, and then we'll come back down to see what's happening in New Zealand. So I'd like to start with a recap of where things are at on the international framework. The high watermark of international climate diplomacy in recent history, of course, is the 2015 Paris Agreement. With the tailwind of the last year of an Obama presidential term and energetic support from China, this Paris Agreement saw a rapid set of ratifications which allowed it to come into force in November 2016, with its first commitment period for nationally determined contributions starting in January 2021. Now, you'll be familiar with the Paris Agreement, I imagine, but just to recap, some of the key commitments in it included this explicit commitment by parties to restrict global average temperature rises to well below 2 degrees Celsius, aiming for 1.5 degrees Celsius, and aim to achieve a balance between emissions and removals in the second half of the century, and the system for voluntary commitments, NDCs, which would be reviewed in 5-year cycles informed by regular stocktakes. Now, the Paris Agreement, as these international instruments often do, was at a relatively high level. And what needed to happen was it needs to be operationalised through the development of a really detailed set of rules and modalities, which include, importantly for New Zealand, the standards and the arrangements for land use accounting, also the arrangements for international emissions trading. Negotiations for these rules have been taking place over the last couple of years in Marrakesh in 2016, in Bonn last year, in Bangkok as we speak, and they're scheduled to be finalised in December of this year at COP24 in Katowice in Poland. Before finalisation of the Paris rulebook, potentially later this year, or beyond finalisation, the conferences will continue. There will be further COPs, and the first commitment period, as I said, will happen in 2021. Now, just before that, on the 4th of November, alarms will be going off in electronic calendars all around the world, because this is the earliest date that the US can withdraw from the Paris Agreement under the terms of that agreement itself. The 4th of November is the day after another significant date, which is the 59th quadrennial US presidential election. So all bets are off really for 2021. Just before we leave the international law framework, I should mention that not all of the issues on the international framework are taking place within the UNFCCC. Important aspects of climate change law and policy happen outside of the UNFCCC, including the World Trade Organization. Now, the WTO is facing a number of Trump-shaped challenges of its own right now, but an important plank of New Zealand international climate diplomacy has been advocacy for the elimination of fossil fuel subsidies, and it's taken that battle to the WTO last year, and it will be continuing to do that in coming years. And I've been involved in a long-standing research project looking at New Zealand's policy on fossil fuel subsidies, and I will continue to follow that with interest. So, that's what's happening in the international framework. I'd like to now turn to some activities of the overseas courts. Bloomberg suggested this week in a report that some of the cases currently before the courts involve groups seeking their tobacco moment. In the 1990s, after years of losing cases against tobacco corporates, judges and juries started returning verdicts that resulted ultimately in settlements totaling $246 billion against tobacco corporates and permanent changes in the sale and marketing of cigarettes. And this, it is said, is a model that climate change activists would love to duplicate. Now, we get a sense of the extent of international litigation on climate change from a database which is in the previous slide, but I have no idea how this goes backwards, so I'll just keep talking. But a Centre for Climate Change Law in Columbia University reports that there are 901 climate change cases afoot in the United States at the moment, around 265 climate change cases around the world, and I suspect that that number is conservative. So I'd like to start by talking about some of the significant international climate change law cases that are happening at the moment. And I mean, I'll talk about some mitigation cases and then we'll move to some adaptation cases. I mention these cases, and they're a selection only, not only because they provide an interesting flavour of what's happening internationally in the climate change world, but also because increasingly the judicial pronouncements in these overseas cases are starting to be cross-fertilised into New Zealand case law and in other decisions in other parts of the world, including some of the cases that I'll talk about in a minute. So at the top is the Agenda Foundation case. You may well have heard of this. This is a case involving a Dutch environmental group who sued the government of the Netherlands in 2015, famously securing a judicial declaration that the Dutch government had a duty to take action on climate change mitigation measures in light of the severity of the consequences of climate change and the risk of climate change occurring. Now, the Agenda case may not quite have been the case that lodged 1,000 lawsuits, but it has been influential internationally in encouraging groups to consider the use of litigation as a tool to influence policy. And that's played out in New Zealand as well in the Thompson case that I will mention in a minute. The Agenda case has been appealed by the Dutch government and we're expecting a decision on that appeal in the next couple of months. The next case is the Juliania and the US case, probably the highest profile climate action currently before the US courts. This is a lawsuit brought by 21 young plaintiffs who allege that the US government is causing climate change in breach of its obligations or in breach of the rights of young generations to life, liberty and property under the US Constitution. And they're also arguing some interesting points regarding the US public trust doctrine. So this case has got quite a way to go substantively, but it's already been the subject of some historic decisions where attempts by the federal government to have this case thrown out of court have been unsuccessful, and that case will continue to wind its way through the court system over the next year or so. In Norway now, the Feringen Greenpeace case is of interest because it raises some matters which have come up in the New Zealand courts in the last few years. In part, this involves a testing of the obligations or the legal obligations of the Norwegian government for its liability for the effects of climate change concerning oil and gas which is extracted in Norway but sold overseas and burnt overseas. Now, this came up in the Bullacol case. There was an initial decision against the plaintiffs which has been appealed, and we'll get an appellate decision on that in the next year or so. The final really interesting one for me is the São Luciano Lulia case, where we have a representative from a developing country who has sued a large electricity generation company in Germany for the climate change impacts of the melting of mountain glaciers in Peru. So we have a Peruvian plaintiff suing an electricity company in Germany for the impacts of climate change. You might think that that case would just go nowhere, but again, it has succeeded in resisting an initial strikeout attempt, and it's now working its way through the evidential process where the courts in Germany are looking like they will consider this and will rule on this in the next year or so. So that gives you a sense of what's happening on the mitigation front. I'd like to quickly talk about some adaptation cases which will be of interest to you given this audience. There are two sets here. The first two examples both share some similarities. They involved claims against, they involved the testing of planning decisions in relation to developments which would be impacted by climate change. The first one in Gippsland, South Victoria, the second in Castletown in Wales, where consents for development were both refused amongst other reasons because of the risks of flooding exacerbated by climate change. The second two cases, one in Canada, one in the United States, both involved lawsuits either against the federal government or sub-federal government arms for property damage which had occurred following devastating floods in Canada and the United States. The St Bernard Parish one following Hurricane Katrina. Both cases are still at large. The Canadian case has been the subject of a success and a failure. The St Bernard case is also under appeal at the moment. But it gives you kind of a sense of the types of cases which are occurring internationally and which we may well see in New Zealand in the future. So I've been asked to talk briefly about local authority legal obligations in the climate change area. As leaders and officers of the frontline local government agencies on many aspects of climate change, you'll be well aware of the Council's obligations in this area. But this might provide us with a little bit of context for the rest of my presentation. And on this slide, I note just some of the many legal sources of duties and powers on climate change, and it's not exhaustive. Many of the statutes or the components of the common law have obvious relevance to climate change. We start appropriately perhaps with the Resource Management Act, the 2004 amendments to the RMA as interpreted by the Supreme Court in the Greenpeace case from 2008, the Buller Coal decisions in 2013, significantly curtailed the ability of local authorities to address climate change and mitigation matters, but affirmed their obligations in the adaptation context. And there is a large and growing body of New Zealand case law dealing with situations similar to that Gippsland and Castletown estates, cases from Australia and the UK. I thought maybe I could pause here just to make an observation or comment on the observation during Janet's talk that the current planning laws are inadequate to address, for example, relocatable housing and these issues regarding the flexibility on linkage with infrastructure. Two initial thoughts, and there will be other views on this, I'm sure. The first is that the RMA itself provides a high-level framework for adaptation issues to be taken into account. We have Section 7I, obliging councils to have particular regard to the effects of climate change. So, in theory, councils could adjust their district and other plans to cater for the kind of situation of a relocatable house. But in practice, that kind of plan change would not be simple at all, and you will know that better than I. There are complex issues of infrastructure provision, of funding, the health issues, the amenity issues, stormwater management, waste management issues, etc. So a great deal of technical work is needed for these kinds of planning provision, and there's a real question in my mind as to whether it makes sense or is even feasible for councils to be undertaking this kind of technical work for these kinds of plan changes on an individual and ad hoc basis. And that leads to this question about the need for better central government direction on this that we might talk about later. Councils' roles, moving away from the RMA now, councils' roles on climate change and mitigation under the Local Government Act as opposed to the Resource Management Act were arguably statutorily narrowed with the removal by the previous government of the 4 well-beings under the Local Government Act. Now, of course, to be potentially reintroduced under the Local Government Community Wellbeing Amendment Bill 2008, which is currently before the Select Committee. We've heard today already about some of the many initiatives that councils are developing across a whole range of climate change contexts using powers under the LGA. So the LGA is obviously important, as is the Building Act. Again, we've heard today about some of the obligations under the Building Act in the climate change context, specific statutory directives to consider natural hazards, including those connected with climate change. So there are many sources of potential legal obligations for councils, and we don't have time to talk about them all. As well as some of the statutes, we've got the local agoina, under which limbs are provided, and then we have bodies of the common law, tort law, negligence, nuisance, breach of statutory duty, and public law, in particular judicial review and public law obligations, which has been a rich source of obligation for litigation overseas. So much more could be said about the adequacy of the statutory and legal framework. James this morning mentioned the 2018 CATWAG report, the recommendations from the Climate Change Adaptation Technical Working Group, which I think contains an accurate and concerning assessment of the fragmented, the incomplete, and the sometimes inconsistent statutory framework concerning adaptation. So I commend its analysis, and I hope that some of the central government officers here are taking note both of the recommendations in that report and also the comments that we've had today. Let's now move to climate change in New Zealand tribunals and courts. And I thought I would start with just an overview about climate change in the New Zealand courts. Statistics only tell part of the story, but it's interesting, I think, to look at the numbers of cases involving climate change which are coming before the courts. So we've got the green bars, which is the Environment Court, and the mustard is the High Court, the red is the Court of Appeal, purple is the Supreme Court, and the blue bar is the Immigration and Protection Tribunal. You can see that most of the cases on climate change are involving the Environment Court. Many of them will be involving local authorities as well. Since 2012, there has barely been a year where there hasn't been an important climate change matter coming before the appellate courts, either the High Court, the Court of Appeal, or the Supreme Court. And it's also interesting, I think, to see the numbers of cases which are coming up in the Immigration and Protection Tribunal, where asylum seekers, often from low-lying Pacific atolls, are seeking to rely on climate change issues in order to resist deportation or to secure refugee status or residence status in New Zealand. So it's a growth industry for lawyers. I'm going to talk about just 3 cases in New Zealand involving climate change at the moment. The first one is this case not before the courts but before the Waitangi Tribunal, the Y2607 Matatua Māori District Council case, which is a case brought on behalf of that council but also more broadly on behalf of Māori, seeking relief or recommendations from the Waitangi Tribunal in relation to what are regarded as breaches of the treaty for the Crown's lack of response on climate change issues. Urgency was sought for this claim, and that was denied last year, but denied partly on the basis that there will be a wider investigation, both of environmental as well as climate change issues before the Waitangi Tribunal over the next 2 or 3 years. So this will be a report to keep an eye out for. The second one is the Thompson and Minister for Climate Change Issues. And many of you will be familiar with this, but let me just quickly remind you of it. There was a judgment delivered on the 2nd of November last year by Justice Mallon on an application for judicial review brought by a law student, now a recent graduate of Waikato University, who had the temerity to take on the former Minister for Climate Change Issues, originally Minister Tim Grosser, then Paula Bennett. Ms Thompson's challenge was multi-pronged, but one of her targets was the decision by the Minister for Climate Change to set an emissions target for 2050 under the Climate Change Response Act. And Ms Thompson's contention was that the government should have reviewed its target after the publication of the subsequent International Panel on Climate Change report, the fifth assessment report, which she said shed new light on urgency in addressing climate change. Now, this application was resisted strongly by the Crown, who essentially sought to have the entire case thrown out, partly on the basis, the Crown said, was that these matters are simply not judicially reviewable. They involve issues which are not suitable for consideration by the courts, and so the case should be thrown out. That Crown position was not accepted. The court held that these matters are judicially reviewable. They involve important issues of public interest, and so it's appropriate to consider the appropriateness and the robustness of ministerial decisions in these areas. Ms Thompson wasn't ultimately successful in securing an order from the court that the government reconsider its position, but that was partly on the basis that in between the proceedings being lodged and the decision being issued, there had been a change of government, and the new government had confirmed that it would review the 2050 decision, and so from the court's perspective, it was not necessary to make that order. Sir Geoffrey Palmer has delivered an interesting paper on this decision which comments on it and says too much, in his words, too much can't be expected from judicial remedies in areas like climate change that exhibit a difficult mix of national and international obligations, hard science, high politics and many uncertainties. And to an extent I agree with Sir Geoffrey's cautionary counsel on the limits to what might be achieved in this area through judicial review or other court proceedings. But I don't think that the behavioural disciplines that can result from well-targeted judicial review actions or other litigation in this area should be dismissed completely. There's nothing quite like the rigour of having to comply with discovery orders and the prospects of judicial acid on ministerial evidence to keep Sir Humphrey Appleby honest in this area of public policy and decision-making. And there are two further points. The first is that it's not only central government decision makers that can be in the firing line, local government as well. Secondly, obviously litigation can be and has been brought seeking a more cautious rather than a less cautious approach or a more ambitious approach to climate change risks. This is the damned if you do and damned if you don't point that Janet made this morning, and we see that to some extent in the next slide and the next group of cases. Now, I'm really grateful to Nikki from Kapiti District Council for her really honest, I thought, and open acknowledgement of the challenges that Kapiti has faced in its development of its policy and strategy on climate change issues. For better or worse, Kapiti Coast District Council has become something of a litigious proving ground for local authority adaptation processes, unhappily perhaps for its councillors and officers, instructively perhaps for the rest of us. But we have a couple of cases here, both of which were mentioned by Nikki this morning. One involving a challenge to LIM reports, the content of LIM reports in relation to coastal hazard lines. The second concerning council planning processes for the hazard section of its district plan. We don't have time to talk about this in detail, and this latter 2017 decision at least turned on legal issues that were more to do with the processes for how district plans are developed and what parts might be withdrawn. But I have included it as a telling example of the complexity of the local authority planning processes in this area. Let me finish with some quick comments on legislative developments in this area. And we've heard already David Prentice helpfully outlined the government policy development process this morning, and I won't duplicate that, but we've just finished the consultation period for the Zero Carbon Bill. It's reported that there were over 14,000 submissions lodged on that. Not all of the submissions are available, but many of them are, and they provide a really interesting and up-to-date snapshot of New Zealand responses to climate change issues and climate change policy. Greenpeace is looking for a statutory goal in the new bill of limiting global warming to no more than 1.5 degrees. Greenpeace opposes international carbon credits being used in our domestic scheme. Straterra, on behalf of the minerals and mining sector, believes that the consultation document paints a falsely positive picture of opportunities in moving to zero carbon and says that nothing New Zealand does will influence global emissions or the climate in any way. And there are many positions in between. LGNZ has lodged a really detailed and thoughtful submission which supports the policy development in this area. I was struck, though, by the degree of consensus amongst the submissions. And this is a degree of consensus that I think many other countries, including a certain neighbour across the Tasman, might look at with envy. There seems to be real across-the-board support for the establishment of the Climate Commission, for clearer government targets and arrangements on mitigation, for leadership on adaptation, and that's telling me that I need to stop. And so it will be really interesting to see what happens in relation to the zero carbon legislation, to the ETS review, submissions for which are due on the 21st of September this year, as well as some really important decisions by central government on its role in relation to adaptation. So we're in for an interesting year. I'm going to stop there, and there might be some time for questions, possibly or not. No. All right, thank you so much.